Yes.
Please, Your Lordship, I beg to mention item number 13 and 14. The arguing counsels on leave, Your Lordship. So I pray that this matter come up after 2 weeks.
So all matters,
Yes, Lord.
2020,
Arguing counsels on leave, Your Lordship. So,
you are there. You are in this case.
yes, Lordship. Arguing counsels in a better position to argue this matter, Your Lordship.
Why are you talking about arguing counsel? You are also a counsel who can argue.
Yes, Lordship.
If we keep, delaying matters like this, nothing will be done. All matters we'll have to dispose it of. I'll give you last chance.
Yes, Lordship.
This is for
13 and 14.
13 and 14.
accommodation is sought for on behalf of the petitioner on the ground that the arguing counsel is indisposed. The prayer not be objected to by the state respondent. That is adjourned. This is after.
I'm praying, please, Your Lordship, I'm appearing for respondent number 6.
Okay. 2 weeks.
Obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item number 4. In this matter, I'm praying for 2 weeks time to file my counter affidavit, Your Lordship. 4 to 10. Already informed the other party petitions.
This is for filing of counter.
Yes, Your Lordship, they have filed amended petition on the last week.
Okay.
Also,
You are the newly implemented respondent.
no, Your Lordship, I'm appearing from principle.
I'm the newly implemented.
Have you filed your counter?
We have filed our earlier counter, but they have filed the amended petition, so we'll file our counter affidavit.
Would you like to file your counter, or
We'll file our counter, Lordship.
and why would you file your counter? Anything new against you?
Yes, they have made allegation against us that we have appointed the private respondent.
Or you are the managing committee?
No, we are for principal.
Or principal? Respondent number?
Respondent number 4 and 5.
This letter counsel for the respondent number 4 and 5 has sought for some more time to file the counter affidavit on behalf of such respondent on the pleadings made in the amended petition filed by the petitioner.
I'm for respondent number 6.
Similarly, Ms. Letter counsel for respondent number 6 has also sought for time to file the counter affidavit on behalf of such respondent. Accordingly, on premier, it seems allowed. Place this matter up to 1 week.
2 weeks, Your Lordship.
Whole matter. They've been out of service for since
Yes, Lordship.
2018.
Yes, Lordship.
So how you see now you have to calculate their age. Are they still within the range?
One retired, Lordship. One that item number that 5, Lordship. He has been retired, Lordship.
So nothing survives.
No, my Lord, still my law cause of action serve, Lordship. If the termination goes, Lordship, then he's that consequential
Area pays and all this.
yes, if the court decide otherwise, Lordship. Yes, Lordship. That now, Lordship, in item number 8, Lordship. Item number 8 I could not, because first thing he could not come, Lordship. So I pray for 1 week time, Lordship, to file the item number 8, Lordship.
Yes.
4, 5, 6, 7 I have filed my that amendment
Amended
petition.
petition, yes.
Yes, in item number 8, Lordship, I yet to file. 1 week time, Lordship. And before that I'll file it, Lordship.
Kitugin long haka 4, 5, 6, 7. M8, 8. I go
9, 10.
Mr. Sheikh Learned Counsel for the petitioner has sought for some more time to file the amended petition on the ground that specific instructions are yet to be received from the petitioner. Prayer Lord. This matter is still 10.
10, Lordship.
Harus 10 tu. Lanjut ke 8, 4 to 10. Same. 2 weeks. This is matter of the 2 weeks.
Maju guys.
On supplementary list, item number 1.
Please, Your Lordship. Your Lordship, this is a bail application, Your Lordship, regarding the... Your Lordship, what has happened in this matter was that in the year 2022, Your Lordship, an FIR was filed, Your Lordship, to the effect that, Your Lordship, this FIR is at Annexure 1, Your Lordship. Annexure 1, page number 14, Your Lordship.
Yes.
If I may read, Your Lordship. With reference to the subject as cited above, I have the honor to inform you that my mentally unsound minor niece, so-and-so, has been impregnated by so-and-so, and the matter has been learned to us only when Miss so-and-so was taken to the Nakchram sub-center for some health ailment, and on inquiry she revealed that so-and-so had often committed penetrative sexual assault against her when she went to fetch water from a stream. Therefore, I request you to kindly look into the matter and book him under as per section of law. Your Lordship, considering that this matter is still going on trial, Your Lordship, I will not delve into the merits of the case, Your Lordship. Your Lordship, all I would, my submissions, Your Lordship, they are threefold. Number one, Your Lordship, the charge sheet has been filed, Your Lordship. Subsequently, Your Lordship, after the charge sheet had been filed and registered, a case under special POCSO case number 2 of 2022 had been registered, and Your Lordship, the statements under 164 of both the victim and the complainant has also been recorded. Now, Your Lordship, as of right now, Your Lordship, evidence is still going on, Your Lordship. And Your Lordship, when we had moved bail, Your Lordship, for the accused person, Your Lordship, in the court of the special POCSO judge, Your Lordship, the learned court had rejected our bail, Your Lordship. Your Lordship, that is at annexure number 7, Your Lordship, page number 31.
Yes.
Your Lordship, if I may read only the relevant paragraph, which is the second last paragraph, Your Lordship, of the order.
Yes.
Case is at the stage of evidence, and 7 witnesses have already been examined. So far, out of the total of 10 witnesses cited by the IO in the charge sheet, evidence of the victim and materials on record does incriminate the accused person. Your Lordship, my humble submission is that, Your Lordship, it has been well established, Your Lordship, under law that the deprivation of liberty, Your Lordship, constitute punishment. Now, Your Lordship, punishment it is awarded after the trial has finished, Your Lordship. Now, Your Lordship, liberty, as per the canons that have been established under law, liberty, Your Lordship, can be deprived only under the procedure established under law. Now, Your Lordship, the liberty of a person, Your Lordship, cannot be arbitrarily denied, Your Lordship, under the guise of legal formalities, Your Lordship. Now, Your Lordship, there is no more reason, Your Lordship, for the accused person, Your Lordship, to be in jail, considering, Your Lordship, that the fact that the charge sheet has also been filed, the evidence of the victim and the complainant also, Your Lordship, has been recorded before the court of the special judge. Now, Your Lordship, it is also established, Your Lordship, that the grant or denial of bail must be rooted with legal reasoning, Your Lordship. That means that, Your Lordship, if a court is supposed to deny bail, Your Lordship, there must be sound grounds, Your Lordship, for the denial of such bail, Your Lordship. Now, Your Lordship, if you look at the order of the special POCSO judge, Your Lordship, the main grounds of the court says that 7 witnesses have been recorded, and Your Lordship, and a total out of 10 witnesses are there. Now, the evidence, just because the evidence of the victim and materials on record, Your Lordship, incriminate the accused person, Your Lordship. In my humble submission, Your Lordship, this does not form a ground, Your Lordship, for the denial of bail, Your Lordship, in this matter, Your Lordship. Your Lordship, because the trial is still pending, Your Lordship, his guilt has not been proven beyond reasonable doubt, Your Lordship. Now, Your Lordship, this has also been upheld, Your Lordship, in various precedents, Your Lordship. I'm sure Your Lordship is aware of the Sanjay Chandra versus CBI, Your Lordship, which is a 2012 judgment, which says that the right of a UTP, Your Lordship, to liberty cannot be denied, Your Lordship, because liberty is a fundamental right that is so sacred under Article 21, Your Lordship, that only when certain legal reasoning, Your Lordship, is given properly, Your Lordship. Now, Your Lordship, this was also reaffirmed, Your Lordship, in Satendra Kumar Until, Your Lordship, versus CBI, which is a very recent judgment, Your Lordship, in the year 2022, Your Lordship. Yeah, my most humble submissions, my prayer, Your Lordship, is that may the accused person, Your Lordship, be enlarged on bail. There's no more need for him to be in custody, Your Lordship. With, of course, Your Lordship, with strict conditions imposed by this court.
When was the last witness examined?
Your Lordship, I'm not sure about the last date, Your Lordship, but the last date was the 24th of March, Your Lordship, which was a Monday. That, Your Lordship, was fixed for the appearance of the accused person, Your Lordship.
How many witnesses were examined that day?
I'm not sure, Your Lordship. Your Lordship, this is all the instructions that I've gotten.
Should have been apprised of the latest status or situation.
Your Lordship, I can find out, Your Lordship.
See, the fact is that if there are 10 witnesses cited,
Yes, Your Lordship.
7 of them have been examined.
7 of them, Your Lordship.
Discharged. So 3 are left.
3 are left, Your Lordship.
Now, let's say, for argument's sake, that the 3 witnesses have already been examined as on the last date. You said on the
24th of March.
24th. Now we are on 27th.
Your Lordship, as per the last date, Your Lordship, the IO, Your Lordship, had prayed that a paternity test may be conducted, Your Lordship, to determine the paternity of the child, Your Lordship, in question here. Your Lordship, the investigation seems to have not been completed, Your Lordship, because they have not prayed for a supplementary charge sheet also.
May please, Your Lordship. Lordship, this case is a very horrendous case, Lordship, whereby the accused in this case is the uncle of the victim. The victim is a 16-year-old girl, and she was of unsound mind. And the uncle being a
Has that been proven medically?
No, Your Lordship, it has not been proven medically.
Lordship, as per the Lordship, as per the position of the health officer, Lordship, she has recorded the age of the victim and of the accused. The accused being a 58-year-old man.
What about her mental condition?
No, Lordship, it has not been attached with this thing. Lordship, if Lordship may be pleased to call for the records, Lordship, then we can settle this matter. Because a copy of the records, Lordship. Because Lordship, as per what have been stated in this petition, Lordship, the uncle, the accused and the victim, Lordship, they stay in the close vicinity of each other, Lordship, and releasing him on bail would be a travesty of justice, Lordship. And it is not a one-time affair, Lordship. It has been continuous actions whereby he has approached the girl at different locations and even in the house, and even the mother of the victim has caught him red-handed in the action in the own house.
That has been noted in her deposition.
Lordship.
Your Lordship, there are discrepancies, Your Lordship, with regards to her statement under 164, her deposition before the court, Your Lordship. There are discrepancies, Your Lordship. Number one, Your Lordship, where she has stated in her 164, Your Lordship, about the occurrence of the incident, Your Lordship, it does not match, Your Lordship, with the deposition that she has made before the learned Pokso court, Your Lordship. Also, Your Lordship, with regards to the soundness of her mind, Your Lordship, a medical board, Your Lordship, has not been constituted, Your Lordship, to determine the same also, Your Lordship.
Lordship, that is, I'm not aware of that. The Lordship can call for the records because that has already been
where
placed.
is the deposition of the complainant, the mother?
The deposition of the
Lordship, the deposition of the victims at annexure 4 at page number 23.
No, the mother would be the best person to, to
Lordship, that has not been
say
attached with this
whether
petition, Lordship.
Yes, not really.
Your Lordship.
The mother would be the best person to say whether she's
Lordship.
of unsound mind or not.
Agree,
because
Lordship.
irrespective of medical evidence or examination, she would know the condition of her daughter.
Lordship.
So, well, that's one thing. Of course, the survivor herself may not be able to say whether she's unsound or not. She may not be in that.
Your Lordship, but for the same also, Your Lordship, a medical board must be constituted, Your Lordship.
Of course, that is a different thing.
Lordship, I can take your Lordship's page number 29, the deposition of the health officer, Lordship. If I can take your Lordship's page number 30, paragraph number 2, paragraph 4. A psychiatrist consultant was needed to know the extent of mental soundness. Advice for consulting. I had been given advice for further instruction.
Your Lordship, this was not done, Your Lordship.
Lordship, so Lordship, right now we have very limited instructions with just this petition, Lordship. If Lordship may call for the copy of the records, so that. But then, even then, Lordship, there are 3 reasons for bail, Lordship, which the petitioner has brought to your notice of this honorable court. Number 1 being minor inconsistencies in the statements made by the victim. Number 2, that there has been conscious consent given by the victim.
That was not this.
Exactly, Lordship. Consent would not be.
That was not the submission made.
Lordship, in
the petition.
In the petition, Lordship.
What the learned counsel has stressed on is only on the fact that liberty has been deprived to the
Your Lordship.
To the accused, who is who has been in custody all along. That's number 1, and number 2 is he is presumed to be innocent until proven guilty
beyond reasonable doubt.
Lordship.
So those are
Lordship, as per the what has been the bail which was denied by the court below, Lordship, she has specifically stated that there are evidences and materials on record to incriminate the accused person, Lordship.
Your Lordship, again, that's a subject of trial, Your Lordship. We're not at the end of the trial yet. The conclusion
Lordship
has not
has,
been made.
in a lot of matters, incarcerated persons who are based on sole testimony of the witness, Lordship, or the victim.
Your Lordship,
Here, Lordship, just on placing on record, just by reading of the deposition made by the witness, Lordship, of the survivor, it shows that there's a strong prima facie case against the accused, Lordship.
Your Lordship, if I may, Your Lordship, as per the established canons of law, Your Lordship, bail is a rule, jail is an exception, Your Lordship. Your Lordship, my main argument here is that, Your Lordship, 164 has been recorded of both the victim and the complainant, and depositions before the Pokso court has also been recorded, Your Lordship, of both the victim and the complainant. Now, Your Lordship, the core witnesses have already been examined. Charge sheet has been filed. Investigation is complete, Your Lordship. What else is there, Your Lordship? Why should the accused person be detained any further, Your Lordship? This will result, Your Lordship, in a gross violation of his fundamental right. Your Lordship, an under trial prisoner is not a convict. Conviction comes at the end of the trial, Your Lordship.
Lordship, I can also state there's a recent judgment of the Delhi High Court, Lordship, in N versus State of another. is cited in 2023 SEC Online Delhi 5387, Lordship. Lordship, I don't have a copy of the. My apologies, Lordship.
If you are citing authorities,
Lordship.
firstly you should.
Lordship.
It is imperative for you to give a copy to the court concerned, also a copy to the other side, so that they can refute by another authority for that matter.
Lordship, my apologies, Lordship, but then, Lordship, to summarize, Lordship, so basically,
I would like to go through the position of the at least the complainant.
Lordship, if the
You have a copy there with you
Your Lordship, the deposition, Your Lordship, I've already annexed it, Your Lordship, in the petition
of the
of
complainant.
the complainant, Your Lordship. Your Lordship, it is at Annexure 5, page number 25. Your Lordship, he is the uncle.
Sorry, not the complainant.
Or the mother.
The mother.
The mother, Your Lordship, I have not annexed it, Your
She has
Lordship.
been examined.
Uh,
Is she cited as a witness?
check, Your Lordship.
You were referring to statement of under section 164. Have you annexed those statement here?
Yes, Your Lordship. Your Lordship, the statement of the 164 of the victim, Your Lordship, the type copy is at page number 22, Your Lordship. I may read, Your Lordship.
Since when was he in custody?
So, Your Lordship, since the year 2022, February, 25th of February 2022.
Heard Ms. Legal Counsel for the petitioner, who has submitted that the petitioner who is the petitioner here, the accused himself.
No, Your Lordship, he is the brother-in-law, Your Lordship.
Petitioner is the brother-in-law of Shri Bihar Ke Sangma, an accused. An accused person pleaded in connection with
Your Lordship, it's special POXO
special
case.
POXO case number 2 of 2022, pending trial before the Leonard Special Judge POXO East Garo Hills, William Nagar. It is the submission of the Leonard Council that on the basis of an FIR lodged before the, where's the FIR?
Your Lordship, it is at Annexure 1, Your Lordship. Page number 4.
On the basis of an FIR dated
2502.
25/2/2022, lodged before the officer in charge, William Nagar Women PS, wherein allegation has been made against the accused in question to have been that he had sexually assaulted, that he has committed penetrative sexual assault on the minor niece of the complainant, for which action against the relevant provision of law is to be sought to be taken against him. In course of investigation, the accused person was arrested and is still in custody till date. Was arrested when was the date of arrest?
Your Lordship, the 25th itself, Your Lordship.
Was
25th.
arrested on 25th to 2022 itself, and is in custody till date. In course of investigation, the IO had come to the conclusion that a strong prima facie case is well made out against the accused person, for which he is made to stand trial before the before the competent court of jurisdiction under the relevant provision of law, particularly under the POCSO Act. The stage of the case at present is for recording of evidence, wherein out of 10 cited witnesses, 7 of them have given their statement before the court and were discharged accordingly. The Land Council has submitted that the last date fixed for the matter was on
24th
24/3/2025. However, on the set date, the IO has made a prayer for the court for conduct a paternity test on the accused person. Since the case of the prosecution is that as a result of the sexual assault perpetrated against the minor survivor, she was impregnated and has she given birth?
She has, Your Lordship.
And has given birth to a child. Hence the prayer. The Land Council, however, has stressed on the fact that since investigation in the case is completed, the statement under section 161, 164 of the relevant witnesses, including the accused person, including the survivor and the accused person, have also been recorded. There is therefore no scope for the accused person to either tamper with the evidence or witnesses at this point of time. While referring to the well-entrenched principle of personal liberty in situation of this kind, wherein a person is incarcerated in custody, thus depriving him of his personal liberty as enshrined under Article 21 of the Constitution of India. Therefore, at this point of time, the accused person may be enlarged on bail with any condition deemed fit and proper to be imposed by this court, comma, employing the principles of bail, I quote Mondo, bail and not jail. Per contra. Anything else?
No, Your Lordship.
Per contra, Mr. E.H. Karwalang, Leonard, additional PP, while opposing the prayer made by the Leonard Counsel for the petitioner, has laid stress on the fact that evidence recorded so far has revealed the complicity of the accused person, which has not been contradicted or refuted in evidence, particularly as regard the statement of the survivor herself, who has cited instances of not only one but about 4 of them where the accused person had committed the offence on her person. The Leonard additional PP has also submitted that the perpetrator, accused person, being the uncle of the survivor, the same has assumed significance as far as the nature and gravity of the offence is concerned. Apart from the fact that the accused person is residing within the vicinity of the residence of the survivor, therefore it would not be proper for the accused person to be enlarged on bail till conclusion of the trial. Anything else?
Lordship.
This court has given due consideration to the submission of the parties and would reiterate that the principle of criminal jurisprudence as far as bail is concerned is as submitted by the Leonard Counsel for the petitioner, that is bail, I quote motto, and not jail. However, it need not be reminded that while considering the question of grant or non-grant of bail, certain principles, factors and parameters or guidelines as was given by the Honorable Supreme Court in a Katana of judgment as regarding the principles of principle of bail jurisprudence, the trying court has to take into account, firstly, the nature and gravity of the offence, comma, the punishment to be imposed if convicted, comma, the antecedent of the accused person, and such other relevant factors. Next. The fact that this court, on perusal of the materials on record, including the statement of the deposition of the survivor, is convinced that prima facie a case has been made out against the accused person, considering the fact that there is no denial that he had committed the offence. However, this is not the conclusive evidence, since the whole body of evidence has to be appreciated by the learned trial court at the conclusion of the trial. Be that as it may, as to the antecedent of the accused person, again, there is no denial that he is the paternal uncle. Paternal uncle. He is the paternal uncle of the survivor, and this by itself would invoke strong emotive reaction, especially in a conservative society that we are living in. Another consideration that has weighed before this court is that there are 10 witnesses cited, and 7 of them have already deposed before the court. Thus, the question of delay cannot be taken as an excuse. Delay in trial cannot be taken as an excuse. Next. On an overall consideration of the facts and circumstances of this case, this court is not inclined to allow the prayer made in this petition. The petition is accordingly dismissed as devoid of merits. Before parting, this court would request the trial court to proceed with the trial expeditiously. If after a lapse of 1 month or 2 months time, the trial is not completed, the petitioner is at liberty, the accused person is at liberty to approach this court for a fresh consideration of his prayer. Petition disposed of.
Daily list, item number 1.
Thank you, Miss. You have done a very good job. Your argument are very persuasive.
Yes,
But
yes, my lord.
facts have to be taken into account.
Your Lordship, I'm entering appearance on behalf of respondent number 3, Your Lordship, in this matter.
3 and 4, same.
Just got 3.
Why not for 4?
I have to see.
Granddaughter,
Yeah, I have to see instructions.
How many respondents are there?
My lord, 4 respondents, my lord. We have taken steps on, my lord, on 17/3/2025, and the office note says that the ID card has not yet been received, my lord. So he is appearing on behalf of respondent number 3. My lord, he can appear for respondent number 4 also, because 4 is the granddaughter.
I'll have to talk first. I have to see instructions first, Your Honor.
4 is granddaughter of
So
3.
now you are entering appearance on behalf of respondent number
3.
What about 1, 2? Who are 1, 2?
Just for 3, Your Lordship.
Just for 3?
Yes, that's my instructions, Your Lordship. Just for 3.
खोल कर दो.
3. So 1, 2 and 4.
Yeah, the service may be awaited.
No, awaited.
Maybe
Not yet
awaited.
completed.
No, because my lord, office note says that AD card has not yet received.
True, true.
So let us wait for the service report. AD card, my lord.
You seek instruction as far as 4 is concerned.
Yes, my lord.
If they are, honest,
4 is granddaughter of 3.
I'll just see instructions. For the time being, Your Lordship, I'll file my power for respondent number 3, Your Lordship.
Please.
And of course, the date.
Heard Mr. Letter Counsel for the appellant, who has submitted that the notice, that the service report as far as the notice issued upon respondent number 1, 2 and 4 have yet to be confirmed as to whether the same have been duly affected or not. It is prayed that some more time may be allowed for the service report. Next. As far as respondent number 3 is concerned, Mr. Letter Counsel has entered appearance. Accordingly, on preamid, this matter is now adjourned to await the service, the confirmation of the service report as far as the said respondent 1, 2 and 4 are concerned. This is matter after
4 weeks, my lord.
4 weeks.
Obliged, my lord.
Obliged.
Item number 2.
Please, Your Lordship. So the petitioner's grievance here is that their properties are sought to be acquired under the Land Acquisition Act without payment of any compensation. Now, the instructions that we have is there was some exercise which was being conducted by the state to verify some claims and counterclaims with regard to title in respect of these properties. So it appears that that exercise is still underway. I'm not really sure what the reason for the delay is, my lord. So if lordships will permit us to file an affidavit to bring this on record, then perhaps lordships can give a direction.
Why would the authority or the collector verify the title and
Without verifying title, perhaps they cannot even release the compensation. There has to be some prima facie.
Unless there's a pending litigation,
So there appears there's some mention of some claims and counterclaims. Yes. They're yet to give us those details. Okay. I'll file an affidavit, my lords. Then perhaps lordships can direct them to complete it within a stipulated time period. That would.
Anyway, the main issue here, my lord, is whether an award was published or not. According to our information, my lord, there was no award also, and that's why the trial court also at one point of time had remitted back the matter to DC. Because if the award has not been published, the question of then the new section will come into play.
This is under the old act.
Old act,
lordship, under the old act.
So section 4, 6, 9, 11, everything complete.
All that is
but
complete.
The award, no, my lord, the award in view of section 24,
section 11.
Lordship.
What is the award made under?
Well, the award is made under the.
Old Act it's 11, my lord, no doubt. But section 24 of the new act says that if the award is not passed within a certain period of time, then that lapses, and they have to
First we have to look at the proceedings.
Lordship.
Yes.
If it was initiated under the old act.
Lord, it is under the old act, my lord.
Yes. Then eventually, I don't know. I have not.
No. Eventually, what would happen, my lord? Even if it's under the old act, Now, if an award has not passed within 1 year of the passage of the new act, then the government, what will have to do, they'll have to make a fresh reference under the new act.
Exactly.
That's why the query by this court was whether an award is there or not, first of all. Whether we come to the question of who's entitled to the...
But Mr. Dingdo, you have preferred a writ?
Yes, we have preferred a writ because the matter was referred by the special judicial officer, it was referred back to the deputy commissioner, collector. Now that was which year?
To confirm the, as Mr. Sen
2019.
As Mr. Sen was saying, to confirm the ownership.
No, subsequently in 2021, there is internal correspondence between the additional DC and the BDO that there appears to be some sort of claims with regard to some claims and counterclaims which require to be verified. I understand from 21 to 25, we don't know what's really happened. In the meantime, the petitioners have preferred an RTI application. If Lordship will just see the RTI at page 97. So the petitioners' plea that there is no award stems from this reply. The reply is at page 97.
Yes.
Please see the first query, my lord. Whether any award has been made passed in respect of the land acquisition proceedings for construction of IBBF from so-and-so to so-and-so under Shela Dorbar. In response, please see the information provided. Land compensation was partially paid to the landowners, copy enclosed at Annexure 1, except for those where the verification report of the claims and counterclaims of the rightful landowners is still awaited from the office of the BDO, Shela Bholaganj. Now, this does not really say whether an award was passed or not passed. They are inferring this. So the RTI cannot be treated as evidence as to whether an award actually exists or not. So I'm yet to receive that information. I know my predicament is that I've not received proper instructions.
Let them receive instructions.
Lordship.
But well, our specific question was whether there's an award.
Exactly. Yes. Now, you either, it's not a question of seeking instruction.
Lordship.
It would be incumbent upon you to advise.
Yes, absolutely.
As to how to proceed with the matter without
Lordship.
Trying to drag this matter before this court.
Lordship.
If that could be resolved, then the petitioner will not press this matter.
Yes. That's why we were forced to come before this court.
Well, I'm just informed that apparently Lordships had taken up this matter as special judicial officer. If your Lordship just see that, this is a correspondence from 2019.
Would that have any effect?
No, I am not. I'm just placing it. I'm just bringing it to your Lordship's notice. Anyway, we'll take instructions and file a detailed affidavit in this matter.
For 2019.
Reference procedure.
This is not will not come in the way of this court.
I've been out of the circuit for so long.
Anyway, no effective order has been passed by Lordship with any of these matters.
No, I have no difficulty. I'm just placing it before your Lordship's notice.
Yes, no.
Unless an effective order has been passed.
No adjudication has been made.
Yes.
I think this, probability is a administrative order.
Yes.
So what do we do?
I'll take about 3 weeks time to file a detailed affidavit on this issue, and thereafter Lordships may direct the state to dispose of whatever verification is required to be done within a stipulated time period, if at all that is necessary.
It all boils down to your filing of the counter, which you have not done.
Lordship. Yes. Because we have not even received proper instructions with regard to the existence of the award.
Mr. Sen, yes, Senior G.
G, my lord.
Leonard G has submitted that the counter affidavit on behalf of the respondent could not be filed today and has prayed for some more time for the same. On payment, same as law, this is matter after 3 weeks.
Lordship. I'll leave it.
I know.
Item number 3.
My lord, I have written a letter to the Deputy CEM, my lord, who is supposed to take the matter, my lord. Yeah, my lord, I have been instructed, my lord, to inform this honorable court there is a session going on in the district council, my lord. We are praying for 10 more days' time. There is already a status quo order, my lord. So,
My lord, I received instruction, my lord, with regard to, from my client. The petitioner herein, my lord, in the
You are appearing for respondent number 6.
correspondent number 6, my lord. Yes, my lord.
So,
I'm praying for 10 days time, my lord, to file my affidavit.
So need some more time to file.
Learned counsel for the respective respondents has sought for some more time to file the counter affidavit for pre-allow. This is matter after.
After 2 weeks.
2 weeks.
2 weeks will do, my lord.
The interim order will continue.
It will continue. Status quo order will continue.
What was the order passed as far as the interim order is concerned?
Status quo, my lord.
Status quo.
It may be mentioned that the status quo order passed by this court would
Continue till then, my lord.
continue till the
Next
returnable date.
Highly
Or until further orders.
highly bench.
Item number 11.
My lord, as per the last order,
Yes.
that is order dated 5/3. Heard so and so. Respondent one has submitted that under instruction, the respondent number 1 is willing to settle the matter amicably. However, even on representation in this regard, no response has been received from the concerned respondent. Mr. So and so has, however, submitted that he has not received any instructions till date. Acknowledging the positive response made by the respondent number 1, this court would grant the parties further side. Now, my lord, we have written to them since 4th of December 2024. They have not responded. So, my lord, my prayer would be let the court pass necessary orders. We have shown our, as per the views of this court, we have approached them. We said we are willing to forfeit 25% of the decretal amount, but still they are not.
Why?
They have not responded.
No, have you really sat across the table?
Not yet, my lord. My lord,
they are not.
I receive a copy of the representation filed by the petitioners, by the respondents on few days back, only few days back. So, you know, kindly accommodate me for another 10 days time. My lord, I may kindly be accommodated.
My lord,
for
let
10
this
days
be
at
on
least.
record, man.
A copy of this, I have received this only about a week ago. So I will approach the concerned department with this letter, and I will have my instructions ready by the next week. I mean, on the next date.
Mr. Gautam, this was written as far back as 4th December.
Of course it was, man. Of course it was.
Now we are in March. At least you should.
My lord, a
you
copy
should,
of this letter
you
was sent
should
to me only 1 week
you
back.
should evince interest in the matter. Otherwise, this court would,
My lord, kindly give me one last opportunity, man. Let the matter come up after 2 weeks. In the meantime, I will have some concrete instructions whether they are willing to settle the matter or
not. Let it be recorded.
Yes, of course.
Yes.
Mr. T.T. Denver, Learned Senior Counsel, along with Mr. C.C.T. Sangwa, Learned Counsel for the petitioner, for the respondent number 1, has submitted that pursuant to the order of this court, the respondent number 1 had preferred a representation before the concerned authority with the indication that the said respondent is willing to settle the matter amicably outside court. However, till date, no response was forthcoming from the part of the concerned authority, including the state the state government. Next, at this juncture, Mr. C. Gautam, learned counsel for the
State.
state
State in CRP number 28.
Petitioner in CRP number.
For the petitioner state in
CRP
CRP
number
21
28.
28 of 2016 has submitted that though he is in receipt of the said communication dated 4/12/2024, however, no specific instructions have been received from the authorities concerned. However, the Learned Counsel would submit that an endeavor will be made to ensure that the matter is settled amicably unless otherwise directed, and as such it is prayed that some more time may be allowed for negotiation to be initiated in this regard. Next, this court, on the prayer of the parties to try and settle the matter amicably, has given them sufficient time to come to any decision in this regard. However, even till date, the parties have yet to sit across the table and discuss the matter. Be that as it may, for ends of justice, be that as it may, the court would further allow the parties to try and resolve the matter amicably, failing which, matter will be taken to its logical conclusion through the judicial process available. On prayer meet, list this matter after 2 weeks, 3 weeks. I think
as far as CRP 21 is concerned, state is respondent number 2. But since my friend is already pursuing the matter, let him pursue the matter.
It's the same, because the director of sports, my lord, as I said, is the same person. He's also the secretary of the State Sports Council.
We don't know who is who.
Yes, that's what. That's why the whole.
My lord, in one case, my friend is leading the matter.
My lord, in CRP,
CRP filed by the state.
Who is finally required to pay? Is it
finally
the
sports department? Yes.
Sports department, sports council. I think there are two.
Finally, the public exchequer is going to pay if at all any payment is to be made.
One
the burden will be borne by the public exchequer if at all any payment is to be made. But under, of course, under different nameplates.
For the purpose of audit, it has to come
through
the proper heads or proper channel.
There will be proper assignment
That
of
is
time.
for you to decide who is to pay, if you agree. If not,
then the court will pass.
Matter will be taken to its logical end. 3 weeks.
3 weeks.
Item number 12.
Your Lordship, as per the directions of the last order, steps have been taken in issuance of notice to respondent number 5. We have taken we have served them a copy of the petition, Your Lordship.
Any report?
That's all, Your Lordship.
Service report?
Oh, we haven't got that, Your Lordship. I'll file it on the next date, Your Lordship.
Have you affected? The notice has been affected?
We have served it to them physically, Your Lordship.
Oh, physically?
Yeah, physically through the council representing the Union of India.
Why they are not here?
We were just there, Your Lordship.
Mr. Learned Counsel for the petitioner has submitted that a copy of this petition has been served upon the Learned Counsel appearing for the respondent Union of India. However, no acknowledgement of the same has been made before this court, since none has appeared on behalf of such respondent. However, the Learned Counsel for the petitioner has, however, submitted that some more time may be allowed for the petitioner to confirm the receipt of the said notice and to apprise this court accordingly. On premium, this is not up to. What about you, state?
Lordship.
You are appealing for the state?
Yes, Lordship.
Are you filing your counter?
Lordship, we've already filed a counter.
You have filed a counter?
Already filed a counter,
Oh.
Lordship.
Oh, this is an old matter.
Yes, Lordship.
Mr. E.H. Kharwala and Learned Counsel, Learned Additional Senior GA has appeared on behalf of the state respondent.
Much obliged.
Can you listen matter after? This is matter after 3 weeks. 2 weeks.
Obliged.
Item number 15.
Kita kira file na sebeli ka. Pasna numusna.
My lord, in this matter, on the last occasion, my learned friend has pointed out the copy of the cross-examination of the PW2 is not there. We both of us have cross-checked. It is there, my lord. It is in the paper book. Only the mistake committed from our side is that instead of placing the cross-examination after the chief, cross-examination was put first and chief comes later. Because of that, some confusion is there.
So the horse before the cart.
Since the papers are there, only other aspect of the matter, my lord, the table of the index, my lord. Some pages are, my lord, pages are available, but pagination is not correct. So if Lord should allow me to correct it to tomorrow.
35 pages are not been indexed, my lord.
In the index, the last page of the index.
Mr. Sangreso, would you require the the whole paper book to be revised?
It may not be required. It may not be required. Only this index pages correction will be there. That will be clear, madam. The remaining page proper paginations are there.
The only thing is, I'm not like my friend has submitted is that why I couldn't find it, my lord, because the in chief has been the cross has been put in front. Then some other witnesses, then some other documents has come in. Then it's not in.
So it was
in
not
order.
put in order.
In order,
Yes,
my
in
lord.
order.
It's not
That
in
is a
order, my
mistake.
lord.
Have you done that?
My lord, since it is there, my lord, instead of recorrecting the entire paper book, if lordship allow me to correct the index, my lord.
But how would you do that? See, the pagination will all go wrong then.
But paginations are in order, in fact. So without touching the pagination, my lord.
You see, for example, what Mr. Kriyama said, if the cross-examination is at page 55 to
My lord,
57,
no.
and then the chief comes at 75,
Your lordship.
My lord.
75, 76, suppose, then how would you reconcile that?
That is not in order, my lord. That
You
is-
have to, you have to plug out this page 55, 6 and put it after 76. So that exercise has to be carried out by you.
Well.
Then you renumber the pages.
But in that case, my lord, allow me to do the correction.
That
By
has
tomorrow,
to be
we'll
done.
be
Otherwise, this court also would be difficult.
Difficulty will be there.
difficult,
Even for us, that's why, my lord, I couldn't find it. I found out the in chief. The cross has been put way ahead, like
You have to
But
pay.
we-
You have
we'll
to
make
pay
it.
extra for the new spiraling. To do that.
But I'll do it and submit tomorrow in the court. Since lordship has heard the matter, may I propose a date on 8 or 9? Since lordship has heard me, only my learned friend will advance his argument.
in the meantime, my lord, as your lordship indicated, they will have to. He will
I
have to
can-
rectify the entire thing first. Then pagination have to be rectified.
That of course. You have to take back this and then get
My
it.
lord, yes, my lord.
So 9th,
Yes.
Inform me to me then.
on premier by the parties, this is matter on 9th.
In the meantime, they will rectify the entire defect.
Yes, in the meantime, you do that.
Well, ample time is there.
Please.